Yes, so greetings from Berlin. The first day we have the sun, so it's connected to this great conference probably. I would like to talk to you about the newest or a kind of new cases from the European Court of Human Rights last autumn that mirror our European regulation on hearing of the child. So before I go to the specific cases, I would like to remind you very briefly about the actually existing regulation, what we have, and they're very important. So when we talk about the hearing of the child, we have to keep in mind that it might have threesome meaning, because for the judge, it might be generally very important to know what the child said, because it impacts on our decisions. And we have even explicit regulation in Article 13, Section 2 of Hague Child Abduction Convention, when the child refuses to go back to the country of origin, the judge has to take this into consideration. In the German law, we have similar provision regarding parental responsibility. The judge has to take in consideration whether the child says, I don't want that another parent will be having parental responsibility about me if the child is over 14 years old. And another very important meaning, and this is the main topic of this hearing today, is what does it mean in the procedural context background? Because we have, as you can see, international consensus in the United Nations Conventions Rights of the Child. Just wait, yeah, I have to, yeah. Rights of the child. We have also in Article 13.2 Hague Convention, we have the provision that requests us, judges, to conduct the hearing of the children. And of course, if we do so or not, this will be having impact whether decision taking abroad might be recognized in the country. This is the topic that today I'm not talking about. I will be focusing on the second meaning, procedural, a fundamental right of the child. We have internationally actually consensus that the child has to be heard. We had already 2010 guidelines of the Committee of Ministers of the Council of Europe. And I'm sure when I ask you all, everyone has the same opinion. Yes, we have to hear the children in all matters that affect them. The children have right, not the duty. It's important to stress this, to be heard and express his or her views. We, as a judicial or legal professionals, we have to ensure that the child is able to participate in the proceedings, is well informed. We have to communicate with the children on their level of understanding. We have to hear their wishes. Okay, so far so good. I think everyone has this opinion. And then when we go to the praxis, 2018, there was very interesting mapping, a country data collected by Fundamental Rights Agency in Vienna. And I am sure there haven't been, unfortunately, a lot of changes. And this data, they collected data about national regulation, in which, on which condition the children are to be heard in the proceedings regarding parental responsibility. And as I said before, the child-friendly justice doesn't request any minimum thresholds. Nevertheless, we have, as far so good, let's say the half, no minimum of the countries, no minimum thresholds in 14 states, but we still have at least, if 11 countries, we have thresholds, that the children are to be heard only when they turn past certain age, 10, 12, even 14. And this issue is not regulated in 3 states. Also, I would like to come back to Brussels A and B regulations that we knew when Brussels IIa regulations, we had actually no specific for parental responsibility cases provision. We had only in Article 11, Section 2, concerning the child abduction cases, that the child has to be heard in these cases. We didn't have any harmonization on this topic. We had only national standard of review and design how to conduct a child hearing. And again, I said before, we are all sure we should be hearing the child. We had 2016, quite shaking in my point of view, a survey conducted by our English colleagues that in child abduction cases, then even is more need to need the child, because as I said, it's not only procedural right, but also it should give to the judge reasons for decision. The children were heard only in 20% of the child abduction cases. So this is still the situation. I think, of course, it's better, but still we have to keep this in mind that in the praxis and theory sometimes take the different paths. So there's no surprise that one of the biggest objects and aims taken by Brussels IIb regulation was to strengthen the right of the child to express his or her views. And also what is very important for me when we read the whole regulation at recital 19 explicitly underlines that we have the principle of the best interest of the child, and this principle has to be interpreted in the light of the international sources. This is the principle now led by the Brussels IIb regulation. And we finally, I'm very happy about this, we have in Article 21 expressly regulation about the right, not duty, well noted, of the child to express his or her views. This Article 21 also applies to Child Abduction Convention in Brussels IIb. As you know, it's great that finally we can explicitly recognize between regulation regarding to parental responsibility and to proceedings under 1980 Hague Convention. Always it was mistaken. There are two different kinds of proceedings with two different subjects. And Article 21, in my opinion, introduced an autonomous fundamental procedural right for the children to be heard, very important. And we have also autonomous interpretation in which situation the children have to be heard. But however, the details of child hearing, in particular who, how, where, is still left to the Lex Fori. So we have this autonomous interpretation of Article 21. We have as a judge's discretion if we hear the children or not, but our discretion always, we have to check within the Article 21. And in recitals 39 of the Brussels IIb regulation is stated clearly that it's not absolute obligation for the judges to hear the child. We have to also, in this case, check if this obligation, if the hearing would be according to the best interest of the child. However, we have 2 points. We have a duty as a judges to hear the child, and when we've done this, we have to take the due account of the views expressed by the child. I always say the child has a voice, but not a veto, and it's always reasonable to tell the children while starting the hearing. And of course, we have to always reasonably accommodate the child, that the child has to really free opportunity to express himself or herself. And there is no duty for the child to talk with us, right? If the children don't want, I wouldn't be any kind of pushing them. This is only the right. And as you see, we do not have thresholds. We do not have any thresholds. And this is very important to me because there is still some, let's say, prejudices when the child are young and no one knows how young is to be interpreted. We shouldn't abstain from the child hearing. It causes a lot of stress for the children. The whole situation is already emotional, stressful. However, there have been psychological surveys telling that for the children sometimes it's worse to decide above their head without consulting them. As everyone they won't also have the right to express their views. And of course, the older and more mature the child, the greater importance should be attached to the expression of the views. Also, of course, the child can change opinions. It's normal. There is no binding, any binding on this opinion expressed by the child. And this is what I also tell to the child. There is no fundamental priority of child views over other criteria. It's one of the mosaic stones while we decide on parental responsibility on child abduction cases. But still, we have to at least consider the child's views when we do our decision. And for the judges, it's very important, as I said before, that when we refrain from hearing the child, we should give reasons for that in our decision, and also another courts know why we didn't do so. So I think the forecast will be that we'll be having some unification of the standards. We got the first standards, is great. And then we will be using these new autonomous standards. For example, in Germany, it is very high request that the children has to be heard in persona by deciding judge. I think it will be lower because in other countries it's very reasonable. The judges might not have seen the child, but have professionals like psychologists, experts, that they hear the child and they present the opinion to the courts. Due to the Brussels IIb Regulation, absolutely fine, because who is hearing the child is up to Lex 4. And I would like to talk about the two cases dealing with the question of hearing of the child within the parental proceedings. We have one Portuguese case, we have a second German case. Both are not grand chamber cases. And in both cases, the court stated violation of Article 8, respect for family life. The Portuguese case concerned a relationship between two minors. Mother and father were minor to the time of the birth of the child. And this is even cross-border case, since the mother, C, was living in Portugal and the father in France. And the daughter, I, she was living also in Portugal. But most of the time, she was staying with the grandmother, maternal side. So she was living with C and M in Portugal. The father was in France. And the time when the father became full of age, he applied immediately for the sole custody of the child, and he wanted to establish the child domicile with him in France, and with contact rights granted to the mother. So he said, I have the stable life, I have the means to look after my daughter, I would like to have the child back, I would like to have the child in France. And this time of the application, the child was being monitored by the Portuguese Commissions for the Protection of Children and Youth, since there were some negligence in the maternal family. There were some suspicions that the current partner of the mother is using drugs, and also there were cases of domestic violence. So the child was luckily under monitoring. And we had national courts decisions. At first, provisional decision, interim measures that granted both parents the joint legal custody. And as provisional decision, until we clear the main proceedings, still the child is staying with the mother, and the child should be still being monitored by the Protection Commission. And we had the first judgment of the Portuguese Family Court of first instance that stated, okay, we leave the joint legal custody with both parents, but the child is changing to the France, and the contact rights were granted to maternal side, so the mother C and the grandmother. One reason was exactly this situation, the mother's family. And also what was very interesting, the court conducted hearings and could specifically see evident emotional ties between the father and the applicant. During the hearing, the child was several times in France, on vacations, on holidays. There were deep contact. Following the appeal of the mother, the Court of Appeal upheld the decision, stated in particular this decision that the child has to live in France with their father is in the child's best interest. However, then the Portuguese Supreme Court totally reversed the judgment of the Court of Appeal, or maybe not totally, because he held still that parents should have joint legal custody. However, the child should live with the grandmother, and the mother should refrain from changing the child's place of the residence without judicial authorization. The father got contact rights. And what the European Court in Strasbourg said, it was stated the violation of Article 8. What was noted that Portuguese Supreme Court put too much weight on the mother's interest, because it was not in the Supreme Court decision the child's best interests were not considered that much strongly, and also not the applicant's rights as a father, as the mother interest, not to having the child removed from the country. The decision was a little bit ambiguous, because the Supreme Court both downplayed and acknowledged the risk resulting from mother. There was, as we've seen, some risk from the family regarding the child's well-being, because on one side the court said, okay, we do not, the child is not going to live in France, there's no risk from the mother's side, but the child has to live with the grandmother, and the mother is not entitled to move the child without any judicial authorization. And the court also did not clarify why living with the grandmother was better than with the father, right? There was some, as we've seen, we had the evidence of the emotional bond with the daughter. And for ours today, for procedural topic, it has to be noted this Portuguese court's decision was taken without conducting oral hearings with the parties and the representatives. And also, and it's interesting because the court is speaking explicitly about the failure of the Portuguese court to provide the child with an opportunity to be heard. So the Supreme Court, in the view of the European Court, disregarded the child perspective, didn't listen to the child. The court emphasized again that the children has to be given children that are capable of expressing their views. I don't know if I mentioned there was 10 years old girl. Then they have to give this possibility to be heard. And also, when the children are mature, we have to give them, we have to give more consideration to their opinion. And so, in this regard, the courts say we are not convinced that the whole decision-making process were conducted properly, because we didn't, because the court is not taking all views or duly assured that everyone who is participating, participants in the proceedings, that his views were taken into account. So this was the Portuguese case. We had also from same committee from the court, from the four, a case regarding Germany. They were the divorced couple, and they have, and the case concerned the contact rights of the father. The mother was staying in, the child was staying in the mother's household, and the parents, as we know, all in our cases, they were terribly conflicted. They were in dispute over years. over the applicants over the father's contacts with the daughter, and several provisional arrangements absolutely failed. We had the first instance, the German first instance court decision that ordered contact with the father and the daughter. This is a kind of German institution, a so-called custodian for the implementation of the contacts was temporarily appointed. The court heard the child. The child stated, as several times before, that she did not wish to see the applicants. The child is 11 years old. However, the family court considered this view, but found this gradually increasing the meetings would enable the child to open up against her father step by step. The child is loyalty in conflict, so-called loyalty conflict. Mother might be influencing the child, so it might be good to have this custodian for the implementation of the contacts that prepares the child. Usually in the praxis, this custodian talks to father, to mother, to the child, before contact, after contact, what was good, what was wrong. So it's kind of helping person in this very difficult situation. And then we had Court of Appeal. In Germany is this peculiarity that we have first instance family court, and the second instance goes directly without district court to Court of Appeal. That the court suspended the father's contacts for 8 months. As I underlined, the parents were heard, the representative of the parents, a representative of the youth office and the custodian were heard in person in the front of the court. And the Court of Appeal based its decision on the daughter's will not to see her father. The child expressed this during the first instance proceedings. The court said this is obviously a conflict of loyalty. The child is suffering from, and she should be she should be temporarily withdrawn. It should be given her the peace, the space to recover. What the European Court of Human Rights says. He stated the violation of Article 8. The father also, in this case, tried to complain under Article 6, the right to fair trial. The court said, whatever we state now, violation of Article 8, there's no need further to go to Article 6. And the father was also awarded non-pecuniary damages and also got some amount for his expenses, judicial court's expenses. And why? The most issue was, and probably you noticed this because I underlined this again, that the Court of Appeal abstained from rehearing the daughter, but still based this decision of the statement of the child that she did not wish to see her father. And we had the statement already in the court of first instance court. And the Court of Appeal drew totally different conclusions from the hearing conducted by the first instance court. It annulled the first instance decision, suspended the contact based on the same hearing of the written transcript of that very same hearing by the first instance court. So again, also in this case, the European Court of Human Rights is not convinced that the Court of Appeal has taken its decision on the basis of sufficiently established facts. Because the court of first instance already saw this reluctance of the child, however, decided to go certain, maybe more protective way, however. And the European Court of Human Rights stated, and I like this sentence, that is not to up international judges. However, whether the child has to be heard and how to make opinion of the views of the child. But to the internet, this is everything up to national judges. We decide on this and how we interpret the views of the child. But the international judges watch the procedure. Each court, also in the second instance, should take should take their own steps and establish facts. And in this case, also was the European Court of Human Rights was talking about the failure because the children has not been heard or also has not taken any expert opinion, which also would be possible. And suspension of the contacts, by the way, is quite a strong decision for each one in the family, and to establish the new contact after such a decision is even more difficult than before. So this is in particular what I want to say today to you. And yeah, I'm happy about discussion. Thank you so much.